General's office has formally charged former Ghana Infrastructure Investment Fund GIF CEO Solomon Asamoah and ex-board chairman Professor Christopher Ameyaw Ekumfi for their roles in the controversial Accra SkyTrain project, which allegedly cost the state some $2 million without authorization. Now, the charges were filed yesterday at the High Court's Criminal Division, and they include willfully causing financial loss to the state under the Criminal Offences Act, conspiracy to commit crime through international dissipation of public funds, and intentional dissipation of public funds under the Public Property Protection Decree. Now, prosecutors allege that in February 2019, the accused authorized a $2 million payment from GIF to Africa Investor Holdings Limited for preliminary work on the SkyTrain project, a system that was never built. Now, the payment was reportedly made without proper board approval. Now, the SkyTrain project, initiated in 2018 as a public-private partnership for an urban rail system in Accra, involved a memorandum of understanding between the Ministry of Railways Development, Africa Investors Holdings, and GIF. However, investigations revealed that the $2 million disbursement lacked proper due diligence and violated GIF's governance protocols. I think we can take a listen in due course, actually, to what the AG had to say. He held a presser some weeks ago highlighting some of the cases that he has taken a keen interest in. But we can also listen to the Deputy AG, Justice Shamsai, also weighing in on this SkyTrain saga. Take a listen.
The rest as to whether the company exists, whether there is any investment actually made, whether the money went to some people's pockets, whatever happened, the rest we would present them in court for the judge to decide, unless we are accused of, trying to try the accused persons in the media.
Finally, from me, your boss seems to be one who likes the idea of backing $2 million. If you're able to raise that money, is it okay for the state?
Look, let's be frank here. Our policy of recover the loot is simply primary. I mean, the first objective is to get the money. Because this country, as we know, has lost so much money through some of these decisions that public officials, some political, some civil, have made in this country. The primary objective of the ORA is to recover the money. We are open, and we cannot be tired of saying that we are open for anyone any of the accused persons or suspects in the other cases who think that they have the money and could return the money. We will be happy to have these monies to be used to solve some of the problems that we have in this country. Healthcare problems, transportation problems, salary problems, so many other problems that we have, sanitation problems. President John Mahama is interested in solving those problems, and we need money to solve them. So, again, let me repeat that we will be happy to take any money that anyone has. And, of course, the law allows us to have plea bargaining, which means that based on certain conditions and circumstances, we could vary the case that we put before the court or the consequence of the crimes that we are alleging in court. So once we do that, and let me tell you, a number of people have approached us with offers, some including money being returned. And we have agreed with some of them. And some of them have agreed to be witnesses for us against some of the accused persons. So I think we are on track when it comes to the recovery. There's no better way of recovering the money than voluntary recovery. So if the people are willing to give us, we will take it. But that is not to say that you can keep the money and then serve jail terms and go for it, because there is an active process. The Attorney General has instituted an active process of recovering, tracing these monies. So I would say that whether you do it voluntarily or not, we will do whatever it takes in the name of the Republic of Ghana. to retrieve every pesewa that we can from private hands and restore those monies to the people of Ghana and to the taxpayers of this country. I think for the purposes of the people of Ghana, the rest as whether the company exists, whether there is any investment actually made, whether the money went to some people's pockets, whatever happened, the rest we would present them in court for the judge to decide, unless we are accused of, trying to try the accused persons in the media. Let's be frank here. Our policy of recover the loot is simply primary. I mean, the first objective is to get the money. Because this country, as we know, has lost so much money through some of these decisions that public officials, some political, some civil, have made.
And that's the voice of Deputy AG Justice Shamsai talking about this $2 million SkyTrain saga. And from the Auditor General's report, it states, we noted that the fund's risk management policy, which was initiated in 2017, is still in draft. We advise management to expedite action for the finalization and approval of the risk management policy by the governing board for implementation. We noted that the fund acquired 10 ordinary shares in AI SkyTrain Consortium Holdings valued at some $2 million. The feasibility studies, which will better inform the project's economics and required approvals from the Cabinet of Ghana and Parliament of Ghana, are still not conclusive. We urged management to continue to monitor the feasibility of the investment in the SPV and make the necessary provisions based on the outcome of the feasibility studies. We noted that the fund did not have the certificates of ownership for the equity investments in 3 companies, totaling some 146.6 million Ghana cedis. We advise management to take steps to obtain the appropriate certificates for all of its investments. And we can also take a look at the summary of facts in due course. Let's speak now with Christian Malmhesi. He's a private legal practitioner. We'll pick his thoughts on this particular issue. Hello, good morning.
Hello, good morning, Helen. How are you doing?
I'm doing great. How are you doing?
I'm blessed.
Now, I'm sure you are familiar with at least some details concerning this Accra SkyTrain project and the colossal sum of $2 million that we are told the country has lost out on.
Yes, I've come to terms with it.
What legal breaches are potentially at the center of this SkyTrain scandal? Procurement violations?
Again,
I was asking what legal breaches are potentially at the center of this scandal? Is it procurement violations, financial mismanagement, or abuse of public trust?
I mean, basically, my place basically as a lawyer is to look at what Attorney General has brought out. So that is the issue at heart legally. So any other thing would be basically governance, politics, and socioeconomic.
Right. That's why I was asking specifically what legal breaches are potentially at the center of this saga.
So based upon what the Attorney General has brought out, he has enumerated a number of charges and counts against the persons he believes are suspects to this particular scandal, and he's arraigning them before court for criminal prosecution to start, for them to go through it, and we see what will come out of it, whether they will be guilty at the end of the day, convicted, or they would be found not guilty, and as it is well. So the criminal justice system affords everybody to have fair trial, sorry.
Right.
So we go through it to see what the situation is. Yeah.
Now, as a public investment body such as GIF, what are the legal and institutional safeguards that would prevent such alleged unauthorized or premature disbursement of funds?
Generally, just as any public institution, the public purse is guided by the Procurement Act and other financial laws that regulate some of these things. And so if the public official fails to carry him or herself through this body of laws, then definitely there will be infringement either on the procurement laws or where there was no good bargaining for money, the financial laws would also come in. And when it moves in that area of criminality, intention must be proven, just as the act, which we call the mens rea and the actus reus, so that that particular offense could be grounded by whoever is prosecuting the alleged culpable person.
And from a legal standpoint, what are Ghana's options for recovering the $2 million if the SkyTrain project it was never executed? As we know, we don't have the SkyTrains in Accra. We're out of $2 million. What are our options?
Basically, just as the Attorney General has indicated, through the deputy, the persons who are suspects now, because I think their plea haven't been taken, but it is a situation that I don't know whether one or two, but there has been a request for plea bargain from one or two of them, and that is one of the options available to prosecution to recover money. Yes, prosecution through the full length of trial for judgment to be given is desired. Imprisonment as a punitive measure is always in the fore, but the objective, as I've heard from the learned Attorney General with the deputy, is more of recovery. That's the operation recover and all that. So with the plea bargain you have it is a kind of legal arrangement where there is a request for negotiation based upon the charges put across. Now, it affords the accused person not to go through full trial or indictment, or full trial indictment based upon the charge sheet. Now, the law under plea bargain allows that when one is entering into that, the prosecution or prosecutor must be able to furnish the accused person with all the details. That is evidence gathered, so we call it disclosures. So recordings, evidence, statements of accounts, all that the prosecutor is going to mount against that particular person. Now, when it comes to plea bargaining, the Attorney General himself does it, or under the Attorney General has delegation in terms of the laws that empowers that particular office to other prosecutorial quarters, which includes police and other prosecutorial sectors. So we have not just the police, we have other people who execute this particular function on behalf of the Attorney General. Now, in situations as that, the law says that such persons have to engage the Attorney General for the Attorney General to render consent so that plea bargain would be initiated. Now, when it is initiated, just as I said, the persons must have full disclosure of all the evidence that would be used against him in full trial, so that person, whether by himself or through his legal representatives, will have a fair opportunity to negotiate on good foot. Now, after this has been done, definitely it would be with notice to the court through the Attorney General that the Attorney General and the accused intend to engage in plea bargaining. Now, the most important thing in this legal process is that the court seeks to ensure that the negotiation is free from duress, any form of coercion, is not prejudiced in any way, and the party has not been, as in the accused person, has not been held in any form of undesired legal relationship, such that at the end of the day, when the plea agreement is reached, the court, when it is presented before the court would ask the accused person all these things I have said, in order for the court to satisfy itself whether or not this was free from any kind of coercion, abuse, promise, duress, all those things. Now, it is because when the court adopts the plea bargain agreement, appeal will not lie from it. Now, again, what you must also know by way of education is that with a plea bargain, there are vitiating factors. When we say vitiating factors, there are things that exist to set aside, that the court can look on to set aside the plea bargain. And it includes if there were some of the things that I had mentioned. So the plea bargain in itself can be set aside when the court is of the opinion that it was not procured on proper legal ground. Now, aside that, the court also looks at whether the sentencing in it. So the sentencing in it, so if the person is supposed to get, let's say, 6 years, and in the plea bargain, the Attorney General has reached out that, okay, we would, so for causing financial loss, 6 years, and the Attorney General has reached a position that let's give you maybe 3 months. It is the court to exercise its power under its residual power, or exercise its powers under the laws to see that given this particular sentencing, it is not in line with the body of laws, even though the Attorney General or the parties are at liberty under the said act to have this negotiation, and in exchange of the monies as it is where in exchange for that term of sentence.
Right.
If it is not reasonable under the law, the court has every right to set that aside and impose the proper custodial sentence, even in the light of the agreed amount that is to be recovered. So the plea bargain is a means of the accused person exchanging something, and cutting short the full trial by giving that which he or she has been accused of, especially in terms of money and all of that, for a reduced sentence. And it is not everything that plea bargain comes up with. So issues of armed robbery, murder, rape, defilement, those high felony, treason, all those things, plea bargain does not come forth with under the law, but for corruption, corrupted related matters, plea bargain allows it. So the Act has listed all these things. So basically, by way of education, this is what it entails when we are dealing with plea bargain.
Thank you for that much needed education.
I know it was a loaded one.
But I think we've been able to at least situate it against what is currently ongoing, especially on the backdrop of oral recover all loot, with the expectation of the citizenry being quite high that all these amounts mentioned could potentially go back into our coffers. It's good education to know.
You realize that the government has only 4 years. In fact, it is not 4 years any longer. It is minus, I think, 5 months. So for such trials to run, it might exceed, because averagely trials run unless the Chief Justice has has made that court a special court to try such cases and for it to be expeditious, the case would leave averagely 3 years and end or more, because adjournments would happen and all of that. There will be in situations where an accused person would say, I'm going to the Supreme Court for this, just like the Opuni matter. So the matter would end up overreaching them over the 4 years. And from the objective of the Attorney General, it looks more like he is mostly interested in recovering the looted funds. So plea bargain is one of the options that they are seeking to use. Unless, of course, it doesn't yield, then they have no choice than to go through the full trial to for the court to come out with a conclusion whether the person is guilty or not.
Let me also introduce into the conversation Edem Senanu. He's an anti-corruption crusader, to also weigh in on these matters. Mr. Senanu, hello, good morning.
Good morning.
Hope you're doing well.
By God's grace.
Thank you for joining us on the program. My first question is one where I'm juxtaposing corruption against misgovernance. In your view, does this particular scandal reflect outright corruption, poor institutional oversight, or would you describe it as a toxic mix of both?
Well, it is a mix of both. I mean, on one hand, you have the individuals who engaged in paying for something when they hadn't gotten the appropriate approvals done. And any basic due diligence should have said this company had not in any place produced and provided this service or product, so that one could say for certainty that they were in a position to provide what they claimed they could. And the governor's part or oversight part is just simply how on earth could $2 million be signed off, given all the systems, public financial management laws we have in place, a board, could a board chair and a chief executive sign out with that? That just tells you there must have been some gap somewhere for this to be possible. So it is a mix of the two, and we need to take a good look at that.
And on a broader scale, on a broader level, do you believe some of Ghana's state institutions have been so captured to the point where corruption isn't just incidental, but it's almost embedded in how they function?
Well, I think that we would need to look at it on the merit of the evidence available. When you say some institutions, I'm not too clear which would have in mind. I do know that the evidence from time to time suggests that particular projects and procurement processes have seemed unnecessarily influenced, and you are thinking, now how did that happen? So, in my view, it probably would be particular projects and procurement processes that people have an interest in, that have seen, the kind of outcomes that one would say that, but the laws don't allow this. How was it possible? It clearly means that you had a group of persons who decided together to make this happen, and so there was a network of persons who made it happen. Otherwise, it's impossible for a single person by themselves, given the kind of laws and systems we have in place, to do some of the things we've been seeing. So we would need to look at the institution and see the institutions we have, and then see whether there's a historical record of repetitive corruption cases of this nature. Then you can draw the conclusion that maybe there's some kind of capture.
Now, on the issue of recovery, you'll know that this government came on the back of ORA, which a lot of citizens are quite keen on, this idea of recovering all loot. From where you sit, what is more pressing or more important, recovering the loot or punishing those who have been at the helm of some of these corruption scandals that we hear about day in and day out? What should the focus be on?
Well, honestly, you need a bit of both. You need both to make sure you're retrieving the resources that have been stolen, the assets. But at the same time, you do need some punitive and sanction measures to serve as a deterrent. In terms of international best practice, we always say prevention is better than prosecution, because the concept is that you're going to throw a lot of money, time, and resources in trying to go after and get sanctioning and imprisonment and all that. And sometimes it doesn't yield the result. So you've lost more money. So a cost-benefit analysis will tell you that this wasn't a worthy cost. So the current best practice is that as much as possible, do some negotiation to retrieve, and in that negotiation, some punitive measures other than the usual you are jailed for 20 years, 30 years, and no money retrieved. It is better to get as much of the resources back and still apply some sanction, whether it is monetary in terms of a fine, whether it is some jail term, but not to the extent of the usual or community service, but some form of sanctioning, which includes the fact that if you're paying more, it means that you are being punished for having taken it. So alternative forms of sanctioning that still provide the state the access to the resources, and therefore we are able to continue to develop, is the way to go.
And also, what role should watchdogs, the media, civil society play to ensure that this case in particular, doesn't fall by the wayside or, go quiet, and also other corruption cases that we're being made aware of?
I think that keeping, so to speak, an inventory, what are the cases that have been highlighted, and demanding for updates on each of the cases, status, and just highlighting. I mean, once media is doing that and civil society is speaking, what it does is those who are involved and others recognize that this is very risky ground. When we engage in these activities, we and our families, the embarrassment and the kind of publicity we get would not be helpful. So, and I think that if you look at the OSP, in designing Act 959, we recognize that most of our anti-corruption agencies were not giving feedback or updates to citizens.
That's right.
And to cure that, we therefore said, listen, every 6 months you have to report. In our view, the much more regular or frequent updates are provided, the more useful it is in terms of setting the precedents and serving as a deterrent for those who might want to engage in corruption and what have you. So it is useful to continuously have this discussion. And I'm delighted to know that the Attorney General seems to not shy away from coming to the public. There are those who have been criticizing him.
That's
On the
right.
contrary, for those of us in the space, we think that's the right thing to do. Keep the issues burning, let all of us be aware, and then you have 35 million Ghanaians able to provide you with additional information as and when we come across it.
Interesting perspective there. And as you rightly mentioned, there are those who have taken some issue with the AG constantly, or at least periodically, updating the people of Ghana with updates on these corruption scandals. You say more of this is needed to keep these issues fresh in our minds.
Yes, it is. Look, when the Department of Justice or the FBI in the U.S. are about to take cases to court, so what it is that they've done all the preliminary investigation, they have their facts. A day or even in the morning or when they are going to start the court proceedings, they call a press conference and they tell everybody, well, we are taking this person to court. These are the issues. And then from that point, they keep giving updates. The point is that once it gets into court, these debates are in open court. Journalists will be there. So I think people need to understand the process and not come up with spurious arguments that he should not have done A or should not have done B. To the extent that they are ready to go to court, these issues are going to be in the open anyway. So it is good for all of us to be properly, as it were, informed about the facts and why. And when people have additional information, they would also make that available to the necessary anti-corruption agencies.
Absolutely. Adam Senanu, Anti-Corruption Crusader, thank you so much for joining us and lending your voice to this discussion.
Thank you for having me.
I'll end with private legal practitioner Christian Mamhesi. Christian, are you still with us?
Yes, I'm here.
I wanted to end the discussions with you. I'll get your final thoughts on this particular saga. And from a legal standpoint, what should the good people of Ghana be looking out for next as far as best next steps are concerned?
Oh, I mean, basically, Ghanaians should be more interested in accountability and probity. So they look more and they continue the discerning posture that they had put in. I mean, nobody is declared guilty, but we always have the presumption of innocence. The fact that someone has been arraigned before court does not mean that that person is. So we should allow the person to go through so that he would prove himself. It happens that the person is guilty, then government would be able to also recover. So it becomes a balance of issues, and then at the end of the day, it's the citizenry that wins. So let's keep ourselves